Residential Report Writing and Case Studies. Chapter 3, SR 2-2A, Roman numeral 2, requires an appraiser in an appraisal report to state the identity of any other intended users by name or type. Comment. A party receiving a copy of an appraisal report in order to satisfy disclosure requirements does not become an intended user of the appraisal unless the appraiser identifies such party as an intended user as part of the assignment. Identifying other intended users may not be as simple as identifying the client. In a residential appraisal assignment, there may be a multitude of other intended users whose names we do not know. If our appraisal report will be part of a loan file that is going into the secondary mortgage market, many parties whom we cannot specifically identify may be intended users. Fortunately, we do not have to know the specific identity of all of these intended users, since we may identify them by either name or type. Using language such as intended users include the mortgagee and / or its successors or assigns, or intended users include secondary market participants, covers a lot of ground and is a suitable means of acknowledging the many people in the secondary mortgage market pipeline whom we cannot identify by name. USPAP states that intended users are identified by the appraiser, and this identification is based upon communication with the client at the time of the assignment. Identification of intended users is made at the beginning of the assignment, and the intended users cannot be changed after the assignment is completed. Therefore, it is important that we communicate with our client early on to determine who these intended users are. Remember, the client is always an intended user. Remember, too, that Advisory Opinion 26 warns against changing the report after completion to indicate another party as the client or intended user when the requestor is not the party that engaged the appraiser and was not identified by the appraiser as an intended user at the outset of the assignment. Such an act by the appraiser would be misleading and therefore must be avoided. Clients and intended users may not be changed or added retroactively after an appraisal and report have been completed. Here is an interesting new USPAP FAQ. 133. Shelf life of an appraisal or appraisal report. Question. I've received inquiries from some of my clients asking me how long my appraisal reports are valid. Is this addressed in USPAP? Response. USPAP does not determine the length of time for which an appraisal or appraisal report is valid. Various users of appraisal services may establish their own requirements or guidelines for the validity period of an appraisal or appraisal report. It is also important to note that USPAP distinguishes an appraisal from an appraisal report. An appraisal is an opinion of value, while an appraisal report is any communication, written or oral, of an appraisal that is transmitted to the client upon completion of an assignment. Two dates are essential to an appraisal report: the effective date of the appraisal and the date of the report. The effective date of the appraisal establishes the context for the value opinion, while the date of report indicates whether the perspective of the appraiser on the market and the property as of the effective date of the appraisal was prospective, current, or retrospective. As such, the effective date of the appraisal, the date of the report, or both may be important reference points when determining when a new appraisal or appraisal report is required. The Appraisal Foundation, Uniform Standards of Professional Appraisal Practice, Washington, D.C., Appraisal Standards Board 2020 through 2021, Standard 2, the Appraisal Foundation, Uniform Standards of blah, 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 FAQ. End of page. Quiz is coming up. Start quiz. Number 1. Jeremy is asked to complete an appraisal by a mysterious client who will not tell him exactly why he wants to have the property appraised. Does USPAP permit Jeremy to accept the assignment in this situation? Yes, no, or USPAP does not address this issue. I'm going to lead towards yes. This is a hard one. Number 2. An appraiser may be engaged to perform an appraisal by an agent of the client. True or false? I'm going to go true. Number 3. Mike completes an appraisal for a property owner who is thinking of selling her property and wants to know what she should ask for it. 2 weeks later, the property owner calls and states she now wants to appeal her tax assessment. She asks Mike to change the intended use to assessment appeal. What are Mike's obligations under USPAP? A. He may change the intended use as long as the client does not change. B. He may not change the intended use after the appraisal has been completed. C. USPAP does not address this issue. Or D. He may change the intended use as long as he does not charge a fee. I'm going to go B. You got a 66.7%. You needed 66 to pass. Continue. Or let's review. Jeremy is asked to complete an appraisal by a mysterious client who will not tell him exactly why he wants to have the property appraised. Does USPAP permit Jeremy to accept this assignment in this situation? I said yes. That is incorrect. The answer is no. An appraiser cannot complete an appraisal on a property without a clear understanding of the intended use of the appraisal. Chapter 3, Standards Rule 2-2, Roman numeral 2. Number 2. An appraiser may be engaged to perform an appraisal by an agent of the client. True or false? I said true, and that is correct. Number 3. Mike completes an appraisal for a property owner who is thinking of selling her property and wants to know what she should ask for it. 2 weeks later, the property owner calls and states she now wants to appeal her tax assessment. She asks Mike to change the intended use to assessment appeal. What are Mike's obligations under USPAP? I said he may not change the intended use after the appraisal has been completed, and that is correct. Standards Rule 2-2A, Roman numeral 3. Requires an appraiser to state the intended use of the appraisal. At the time of the assignment, we should be asking our client what the intended use of the appraisal is. In other words, we are asking our client why he or she needs us to appraise the property in the first place. The intended use of the appraisal may be for financing a property, purchasing a property, settlement of an estate, litigation, or any number of other reasons. An appraiser cannot complete an appraisal on a property without a clear understanding of the intended use of the appraisal. Again, the definition of intended use in USPAP states that the intended use of the appraisal is determined by the appraiser based upon communication with the client at the time of the assignment. This is determined in the beginning of the appraisal process and cannot be changed once the appraisal is completed. Our scope of work decisions are largely determined by the intended use, so it is easy to see why a clear understanding of intended use is essential before the assignment can be undertaken. End of page. Standards Rule 2-2A, Roman numeral 4, requires an appraiser to contain information, documents, and/or exhibits sufficient to identify the real estate involved in the appraisal, including the physical, legal, and economic property characteristics relevant to the assignment. The Fannie Mae report forms provide an area to identify the subject property by several means, including the street address, legal description, and assessment number. In addition to filling in the blanks on the Fannie Mae form, we should identify the property through other means sufficient to summarize the relevant information for our client and other intended users. Some other means of identifying the property include photos, sketches, surveys, maps, etc. Additionally, we can provide narrative type summaries of this information, either in appropriate comments section of a Fannie Mae form or in an addendum. Keep in mind that although this course will often refer to the use of Fannie Mae forms for communicating an appraisal report, we can also communicate an appraisal report in a narrative format using word processors, spreadsheets, charts, and all of the other means available to us. Pre-printed forms are one way of communicating an appraisal report, but they are not the only way. End of page. Standards Rule 2-2A, Roman numeral 5, requires an appraiser to state the real property interest appraised. When we appraise, we form an opinion of the value of a right or bundle of rights associated with ownership or interest in a particular parcel of real estate. Therefore, it is vital that we state the precise interest we are valuing. Usually, the interest being appraised is fee simple or fee simple absolute, which refers to the entire bundle of rights. This course will not spend time discussing the concepts related to the bundle of rights or the difference between real estate and real property, but as an appraiser, you must understand these concepts. If you need further information you should refer to a suitable appraisal or real estate textbook. If we are appraising the market value of a fee simple ownership rights of a piece of real estate, we must have some indication that fee simple ownership in fact exists. We can refer to the title opinions or other documents such as deeds to make this determination. If some interest other than fee simple exists at the time of the appraisal, then we must disclose this. For instance, if a life interest exists or a leased fee interest exists, then we would need to disclose this, even if we were forming an opinion of value of fee simple ownership. End of page. FIREA, market value definition. The Financial Institutions Reform, Recovery and Enforcement Act of 1989 is sometimes referred to as FIREA, or the Savings and Loan Bailout Bill. This legislation created the appraisal regulatory system we now know today. Title 11 of FIREA also led the federal regulatory agencies to develop a market value definition to be used in the appraisal of real property that constitutes a federally related transaction by a federally regulated institution. Additionally, Fannie Mae, Freddie Mac, and others have adopted this definition of market value with some minor variants in some cases. Following is the definition as developed by the federal regulatory agencies. Market value means the most probable price which a property should bring in a competitive and open market under all conditions requisite to a fair sale, the buyer and seller each acting prudently and knowledgeably and assuming the price is not affected by undue stimulus. Implicit in this definition is the consummation of a sale as of a specified date and the passing of title from seller to buyer under conditions whereby 1. Buyer and seller are typically motivated. 2. Both parties are well informed or well advised and acting in what they consider their own best interests. 3. A reasonable time is allowed for exposure in the open market. 4. Payment is made in terms of cash in U.S. dollars or in terms of financial arrangements comparable thereto. And 5. The price represents the normal consideration for the property sold, unaffected by special or creative financing or sales concessions granted by anyone associated with the sale. When we prepare an appraisal report in a market value appraisal, we must state the market value definition, meaning we must provide it in the appraisal report, word for word, as it is found in the source. USPAP also requires an appraiser to cite the source of the definition. If you are preparing your report using a Fannie Mae form, then you will find their version of the definition already stated on one of the pages. It is not then necessary to further cite the source. In the case of a narrative report prepared without Fannie Mae forms, the appraiser must provide the definition himself or herself in the body of the report. You are not required to explain or elaborate on the definition of market value. You must simply state the definition and cite the source. Note that this particular definition of market value contains several qualifications, including the requirement that the opinion be in terms of cash or based on financing terms equivalent to cash if the client requests that the market value be based on non-market financing or special financing terms. The report must summarize the terms of the special financing and explain their effect on the subject's value. End of page. I'm going to call it good right there.